Scarlett Wilson was re-elected as the Ninth Circuit Solicitor in November of 2020. Tomorrow, she'll be sworn in for another term. Today, I talk one-on-one with the solicitor for this edition of Quintin's Close-Ups. And if you haven't already, subscribe to my YouTube channel and like Quintin's Close-Ups on Facebook. Solicitor Scarlett Wilson, welcome back to the award-winning Quintin's Close-Ups.
Thank you for having me. Good to see you, even virtually.
Yes, ma'am. You're very welcome. Let me begin, because obviously you are going to be sworn in for another term as Charleston County Solicitor, really the Ninth Circuit Solicitor tomorrow. Where are you emotionally right now?
I lost you.
Oh.
You said, where am I emotionally?
Yes, ma'am.
I'm in a good spot emotionally. I have some things, obviously, with the coronavirus that I'm concerned about as we move forward. But I feel refreshed and renewed and ready to tackle the next 4 years.
And what will the next 4 years be like for your office as solicitor?
It's going to be challenging because, as you know, we haven't had jury trials since March. And while we've been doing our best, along with defense attorneys, law enforcement, everyone else, to keep the justice system moving, when we can't have in-person hearings, that really diminishes or minimizes what we can do. But Judge Dennis has been great about scheduling virtual court to the extent we can have it. And so we're keeping as much moving as we can, but hopefully with the vaccine rollout and with more and more understanding of the virus, hopefully this spring we'll be able to open up and move the cases that need moving.
Speaking of cases, I was just watching this last night on Channel 4's news, and obviously the big topic right now is about Bob McCaffrey. He will have a parole hearing next week, and McCaffrey, that is, was convicted of obstruction of justice, that is, in March of 2019 in connection with the disappearance of Gail McCaffrey, his wife. You told Channel 4 that you will advocate for McCaffrey not to be granted parole. What has the family told you thus far?
Well, my team has been meeting with the family throughout, and they have just been wonderful. They were great throughout the trial preparations and the trial strategy. And obviously, that crime, and we, of course, believe that Gail was murdered, and his refusal to cooperate, and not only not cooperate, but to obstruct, has really damaged that family and caused great harm to his own children and to the community as a whole. Gail was a beloved member of our community, and in a crime like this, we need to see that we get every day we can get out of the sentence that was imposed.
And I know, obviously, you said it might be too early, but the state statute allows a parole hearing once nonviolent offenders have served 1/4 of their sentence. I don't know if you noticed or not, but what is this guy like in jail right now, or where he is currently in custody?
Well, I would have no direct knowledge of that. The only thing we can see is the same thing the public can see, and that is that there haven't been any disciplinary incidents while he's been in jail. But again, he needs to be punished for what he's done, and whether or not he behaves well in prison. Lots of people can behave well when they're under that sort of supervision, that sort of structure, but then when they're out amongst us, they don't do so well. And we believe that he's likely one of those people.
And when will he serve that 1/4?
That should be up in the next 90 days. The statute requires that the Department of Corrections have a hearing within 90 days of his eligibility for parole.
And I know, as I go to the other side, McCaffrey's former attorney, Chris Leslie, told Channel 4 Court he has the right to avail himself of the system to be paroled like anybody else. What's that system like?
Well, he does have that right. We just oppose it being granted. In other words, he has a right to go through the process, and we don't quarrel with him or any other inmate trying to seek parole, but that doesn't mean we have to go along with it. He can have a hearing, both sides can be heard, and hopefully the parole board will agree with our side. The issue is not necessarily with the process, although I do think when there's obstruction related to a violent crime, maybe there could be a different percentage of time that needed to be served before parole would even be considered. But, you know, according to the statute, he falls under that 25% schedule, and so he's on that schedule. We just don't believe he should be released anytime soon. We believe he should max out his sentence.
And what should that percentage be for him?
Well, he should have to serve as much time of the nonviolent statutory scheme, and in this situation, it would be 65%. Now, what I'm saying is perhaps we should look at when there is obstruction related to a violent crime, it falls under another percentage instead of 65%.
And let me turn over to re-election. Obviously, you were re-elected as the Ninth Circuit Solicitor. And I went back on your campaign website just last night, and it says this: a solicitor's office known for principal prosecution, integrity above reproach, innovation, communication, accountability, and victims' rights. Let me ask you this, Solicitor: what's your definition of principal prosecution?
Doing the right thing, looking at cases holistically. Our job is not just to get a conviction. Our job is to look at the case on the whole and see how the community is served, to see how victims are served, and even to see how defendants are served. We don't want to be in the business of making things worse by the way we handle our cases or the way we handle defendants. There are some defendants who can be rehabilitated, and those defendants, we need to seek to do that. Here comes the drill, if you can hear it in the background. Do you hear it?
Yes, ma'am, I can. Yeah. That is an annoying sound, but it's a good sound because what they're doing below me is working on new offices and new courtrooms for the magistrate court. Okay. And so we'll have more offices available on the third floor, some for my office, but mainly for the magistrate's level. So they're working on that now. It's actually a good time for them to be working on it because of COVID and because of the lower amount of traffic coming in. So while it's a little bit of a disruption, it's for a good cause. Yes, ma'am. And let me ask you this.
But as I was saying...
Oh, go ahead. I'm sorry about the delay. I'm sorry. Go for it.
Well, I was just saying, looking at cases and looking at a system that is fair to everyone is what I mean by principled prosecutions, not just being result-oriented, trying to find a solution to a case that helps everyone involved as much as possible. Sometimes that's not possible to help defendants, and sometimes it's not possible to make victims or put victims in a better situation. But if there is a way to do that, and if there's a way to rehabilitate nonviolent folks, that's something that we should strive to do.
And what type of integrity does your office have above reproach?
Well, accountability comes in many forms, and one of the ways that we have increased accountability, which leads to integrity, is posting what we're doing on our website and doing a race equity study and those types of things that show the community that we're not just interested in the result, we're interested in the process and ensuring that the process is fair. Integrity is also important in letting my prosecutors know, my investigators know, and really the whole team know that we don't seek convictions at all costs. The end doesn't justify the means. We have to be above all reproach when it comes to investigating and presenting cases so that everything is above board.
Yes, ma'am. And here comes the construction again. But let me ask you about the racial equity. What data have you been presented so far when it comes to racial equity here in Charleston County?
I don't have data yet. We have been steadily entering our plea offers or our sentence recommendations so that we can see whether or not we are making offers that are on par, that are fair, and that treat white people, black people, Hispanic people the same. And that is not as simple as just comparing what our offer is. We have to look at each case and compare apples to apples. In other words, compare an armed robbery to an armed robbery, and compare a defendant with no prior record to a defendant with no prior record, instead of a defendant with no prior record to someone who might have 3 strikes or might have a lengthy history. So that's been the main difficulty for the folks who are looking at this. As you know, I'm working with Loyola at Chicago and Georgetown University in Washington, D.C. But what we know, and what we know from the CJCC and from others, is that cases don't come into my office at an equal rate. In other words, more cases against African Americans come in than cases against white people. And we have to look at those cases and make sure that we're only prosecuting the ones that have prosecutorial merit. And making sure that if we're more efficient, it's going to help minorities more than white people, because they're the ones in our system. So anytime we can be more efficient, it's going to have an impact on minorities who are within the system. And so that we aren't only looking at race equity, we're looking at efficiencies across the board, because, you know, the rising tide raises all boats and will help everyone. But I don't have the results yet in comparing our sentence recommendations, our dismissals, things like that. We have some 40 dismissal codes, and we have to, again, ensure that when we dismiss, you can't just look at whether a case against a white person was dismissed versus cases against black people. What's the reason for the dismissal? Is it prosecutorial discretion? Is it lack of evidence? Are more black people being arrested on weak cases, you know, that come into my office, and are we addressing those quicker? Things like that. So it's very complex, but I do think that we have the data that we need. There it goes again. Is this a first for you?
I think so.
With the drill? Okay. Sorry about that. But,
hey, listen, it was a good thing I did. Yeah, it was a good thing I didn't go sit down at the Four Corners of Law, because that wasn't my initial location for this interview. But I'm glad I'm here.
Yeah. So I think that we have the data that we need. Another thing that's a little bit of a challenge for those folks who've done this work before. I mean, we don't have just a stable of rookies looking at this. I mean, the guy from Loyola has been doing this kind of work for a while, but South Carolina, the way we count cases is different than the way other places count cases. So we're having to make some adjustments for this kind of work, but it's definitely doable. And I'm hoping sometime in the next few months, we're going to have some harder numbers to share with you and share with the rest of the community. But what I want the community to know and understand is that I'm not waiting to see if there's some sort of unconscious or implicit bias in our work. I'm going to go ahead and presume it, because it's in every aspect of our society. And I'm going to go ahead with training to try to eliminate it. And we've already started that. We've been doing that for quite some time. And I hope that we all will learn from the findings that we have, and are using this time to, especially now that things are slower, we can do more training. There is more time for training. And so I'm hopeful that it will be ready to ameliorate any bias that we see. And I hope that that's already started. It should have already started, since we've been training on this for some time now.
And Loyola is a great school. I got accepted to go to Chicago in that particular school in 2008. But let me ask you this. How many weak cases enter your particular office on a monthly basis?
I can't give you an exact number. I can tell you this. We dismiss, for one reason or another, between 50 and 60% of the warrants that come in. Now, keep in mind, a defendant may have more than one warrant. So, just to use an extreme example for way of illustration, we might have someone charged with murder and 2 or 3 other warrants along with that would not have an impact in the case, or that we review and decide can't be proven. But the murder is still viable and still a good case. So it doesn't necessarily change where the defendant is or his status, but it's a number that shows a dismissal. So, we do dismiss a good number of cases. And one of the things that we're looking at, I mentioned that we have all those dismissal codes. We're going to be looking at what is the reason for most of the dismissals, and then looking further. Say we find that one law enforcement agency has a very high number of cases that we dismiss because of a lack of evidence. Does that mean there needs to be some more training with that agency? And then, of course, you get into cases like domestic violence cases, where you see the numbers very high for victims who won't cooperate, that sort of thing. And what can we do more and what can we do better about supporting victims so that they're willing to go through with the process? So it's going to be very insightful once we can break all of that down.
Yes, ma'am. And let me turn to, obviously, drug weights. I know that one of the prosecutors asked to weigh in, that is, on sentence reform. You know that, quote, "We all agree that drug weights need to be changed. We all agree that drug sentences need to be reduced, and most mandatory minimums need to be eliminated. We had no problem with retroactive sentence reductions for non-victim crimes. We agreed that straight drug crimes should not automatically be classified as violent offenses." What drug weights are on your list right now?
Well, I think we need to look across the board. I mean, it's not just one class of drugs.
Okay.
And we need to totally revamp our approach to opioids. But what we see is mandatory minimums on cases that in other parts of the country probably wouldn't face much time at all. And we need to recognize they're just like any other people. There are people who are involved with drugs who aren't violent people, who don't carry guns, who don't rob people. And we need to not wield a sledgehammer for every kind of case and paint with such a broad brush. I believe in giving judges the discretion that they need in these cases, and ensuring that we reserve prison sentences for the people who do the most harm, and those are the people who hurt others or who threaten others. And most prosecutors agree with me. I'm sure not all of us in South Carolina, there's 16 solicitors. I'm sure not all of them agree with my position on this, but I just don't think the mandatory minimums for someone, for instance, who is dealing drugs but has never committed a violent act, but because of a weight on a scale, maybe looking at 25 years in prison. And I think if you look across the board at how often prosecutors, not just my office, but prosecutors across the state and prosecutors across the country use their discretion to lower the exposure for a defendant. Well, if we're doing that all the time, then maybe the exposure needs to be lowered altogether. And those are things that we can look at with the legislature, and also, in that vein, work on rehabilitation. We've just got to do a better job for the people who do need to be in prison to have opportunities to come out better than when they went in. Because the fact of the matter is, most people who go to prison are coming home. Don't we want them to come home better than when they went in so that they're not a threat to the rest of us?
And let me go back to that. You said, quote, "We agree that straight drug crimes should not automatically be classified as violent offenses." What would you replace straight drug crimes with as far as classification?
I don't understand what you mean. I think it should be nonviolent. I think straight drug crime should be nonviolent. Unless there is some sort of act of violence associated with it, unless there are guns associated with it, I don't think they need to be violent crimes.
And let me go to another issue, obviously, when it comes to, body cameras and whatnot. And you said this quote, when it comes, matter of fact, let's go to that, what you just talked about earlier, rehabilitation and education for inmates. Furthermore, we know that prisoners should be prepared for release starting day one. It is incredibly short-sighted not to be funded to fund rehabilitation and education for inmates. They are coming back to our communities that you just mentioned. Don't we want them to come back better than when they left? Where is the funding for rehabilitation, that is, and education for the inmates?
It's with the legislature, and they have to be the ones to make it a priority. And I think, as prosecutors have learned and grown, I certainly have, as members of the community have learned and grown about what works and what doesn't work with incarceration, I think it's more acceptable. I think that people understand how short-sighted it is for someone who's going to be returned to the community to not be more educated, to not have drug and alcohol rehabilitation while they're in prison. It's putting people out and setting them up for failure, and which sets our community up for failure. So, as with most things, when it's all said and done, it comes down to budgets. And it's a hard thing for the legislature to have all that they have on their plate when you look at things like teacher salaries and things like that, healthcare, all of those issues. It's hard to think about prisoners and people who have committed crimes against others. But again, they're going to be out and about, and we want them in better shape, and we want them productive.
Yes, ma'am. I'm sorry about the mix up with the questions there. It's all clogged up here on my phone. But let me ask you this about, obviously, police officers and body cameras. You said this, quote, "Equip every officer with a body-worn camera and add a criminal penalty for the willful destruction or editing of body-worn camera footage." What's that ideal added criminal act penalty?
I don't know. I haven't given much thought to what sort of sentencing range there would be for that. It probably would be close to the sentencing ranges for obstruction or misconduct in office, some of which carry 5 years, some of which carry 10 years. And notice again, the key word there is willful.
Right.
Officers are under high stress, have to make quick make decisions very quickly. And, things happen sometimes and they don't turn it on. That's a little different than someone who deliberately doesn't turn it on or deliberately destroys something. And technology is developing such that we should be able to eliminate some of that discretion or some of the problems that we see as far as the quality of what we get from body cameras. But I tell you, one of the things that I've seen change over my career is law enforcement's embracing body-worn cameras. The good cops that I know, they want them. They feel like body-worn cameras protect them. They feel like, and they know from research that's been done, that it helps everyone behave. When a citizen who is misbehaving knows and sees that a camera is running, sometimes it tamps things down, and that actually helps officers. And the fact of the matter is, most officers are great people who are doing very hard work, and sometimes they are wrongly accused. And those officers who have that body-worn camera know that they have proof on their side. So I think the community should feel comforted in knowing that most officers want the body-worn camera. So while I do think we need to have penalties, and I do think should be a crime for the destruction of those things, it's going to be very rare that that happens.
And let me ask you two more questions. You also said this too on the campaign website, quote, require all officer-involved shootings and in-custody deaths to be investigated by an independent agency. What independent agency is your office currently using?
Well, again, it's not necessarily my office, it's law enforcement. I just happen in this circuit to be working very closely with law enforcement and to have worked with them to come up with a protocol that we all agree to use, and we use SLED. Now, there could be situations where SLED wouldn't be the agency used if they were somehow overwhelmed with something else, and mainly that would come in to play if there were some kind of state of emergency, a hurricane or something else. And that's why in the protocol we go through basically a plan B. And it may sound crazy, but those of us from around here know what a hurricane can do. And actually, Berkeley County had an officer-involved shooting in the midst of one of the hurricanes we had in the last couple of years. So it's important for the public and the community to know that our agencies have a plan B. So in other words, an agency knows that if SLED can't get there and can't handle it, it's already decided who they'll go to independently investigate. And they want those independent investigations. Ideally, again, going back to budgets, but ideally what the solicitors believe is that there should be a statewide public integrity unit to handle claims against law enforcement that operates throughout the state, that's separate and apart from SLED. But the reality is that would be extremely expensive. And SLED is able to handle it now, but as South Carolina grows, as our community grows, we might need to look at different options. We are lucky in the Ninth Circuit in Charleston and Berkeley counties that we do have agencies that are state of the art. There are some circuits who just don't have that, and so SLED is the only answer. But we do have crime scene units in some of our departments that can handle things just as well as SLED can.
Yes, ma'am. And a matter of fact, you said this too, quote, create a statewide database for police misconduct information and authorize prosecutors' access, that is. How would you create that?
Well, that would have to be created, again at the state level, okay, either through the prosecution commission or through the law enforcement governing bodies, so that there is a repository and officers don't jump around from place to place. There are some ways to check things, but it's not as comprehensive as it should be. We don't feel, prosecutors don't feel, and sometimes we're in the dark. I do think that's improved over the last 5 years or so, but we think we can do more to have that information more readily available.
And you talked about growth. Let me go to that, Solicitor. How does your office deal with growth, with smart growth?
Growth?
Yes, ma'am.
Well, we are, of course, a training ground, which is a good thing. I mean, the reality is most lawyers don't come to prosecution to be career prosecutors. There are a few of us who are. And it helps to have new blood, new ideas, new talents in this field and in any other field. One of the ways that we are growing is we're on the forefront of accepting data and data analysis to help guide us. The only way you can do data analysis is to collect the data, and we're on the forefront of that. Numbers aren't the be-all, end-all. Each case has human beings attached to it, so you can't have cookie-cutter justice. You can't have one-size-fits-all. But you can look at trends and you can look at patterns, and prosecutors across the board, across the nation, need to accept that and be more willing to use that data to guide them. And that's one of the key things that we're doing in my office.
What trends and patterns are you looking at right now, Solicitor?
Well, the biggest trend we're looking at is that with COVID, we aren't able to move cases. And we're seeing the backlog grow. And so we're going to have to make some hard decisions along with the court. As you know, the court controls the docket now about how we docket cases coming out of COVID when we can get back into court. What cases take priority, how often we're in court, what cases does it simply not make sense for us to move forward with. And those are the things that we're looking at and trying to break down to see how many of what class of case we have, what purpose is it going to serve in the long run to see the prosecution through. You know, again, mostly we're talking about non-victim cases when we talk about possibly dismissing cases due to a backlog. I haven't made that decision yet, but that is something that we're looking at, and that is a reality we may have to face. Just looking at numbers and looking at the amount of court we have or don't have, we will have to make some decisions about cases that are not worthy of the court's resources.
And when I look at that backlog, what else will I see?
Well, you'll see that we have been able to move some cases, but again, those cases are usually the cases that don't involve prison time, that many times don't involve victims. I think one of the things that will surprise you if you look at not necessarily the backlog, but look at the incoming cases, is how much law enforcement has changed with who they arrest. You know, the cases that are coming in, while we're not able to keep up with them in court, they've really reduced the number of arrests that they are making. Whether or not that is because crime is also reduced, I don't know yet. But there are also a number of cases that arrests are made that are discretionary, and law enforcement's opting not to make those arrests or either to give citations. And we've seen that especially with marijuana. You know, officers across the board and law enforcement has embraced the idea of not arresting people and taking them to jail for simple possession of marijuana. And I think that's a trend that you're going to continue to see.
Ninth Circuit Solicitor Scarlett Wilson, thank you so much for your time. And again, welcome back to Quintin's Close-Ups.
Well, it is great to see you. I apologize again for the drilling, but it's progress being made, and we hope to talk to you again sometime this year as we come out of the COVID shutdown.
Yes, ma'am. I'll be right here.
All right.